So was that a conscious choice to send an all-women team to arrest Prajwal Revanna?
Yes. Every crime which is happening outside on the road is getting captured.
Correct.
So it has become a good tool.
So do you think taking courage from this judgment, more women will come forward, sir?
Hope so.
Hi, today we have with us BK Singh, Additional Director General of Police Criminal Investigation Department. He is well known for his investigation skills and has led several special investigation teams into very high profile cases. Some of the cases include the murders of editor activist Gauri Lankesh, scholar MM Kalburgi, and the alleged crimes of Prajwal Revanna and also MLA Munirathna. He is also presently investigating the stampede at the recent RCB celebrations at the Chinnaswamy Stadium that killed 11 people. Welcome, sir.
Thank you.
Sir, so we are doing this interview in the context of the recent judgment in the Prajwal Revanna case.
Okay.
So we know that the case actually started in a matter of 1 year and 4 months from the registration of the case. The case completed trial and the punishment was announced. So in such a high profile case, usually we have some cynicism that it will drag on and on. But this is a very unique case where this happened so early. So how did this happen, sir?
See, one thing I can say, because of some provisions of law and the provisions under which this MP MLA courts were created. And third point was, since the accused in this case could not get bail from the Supreme Court also, so it had come that once the trial starts, it has to be on day-to-day basis. The originally concept of MP MLA case court was that the cases which are registered against MP and MLA, trial should be ended within 6 months of the charging the frame. But at the same time, when the accused in the judicial custody, and particularly in rape cases, then the trial has to do on the day-to-day basis once trial commences. So these put two together, the court has taken the way that let us take the trial on day-to-day basis once charge sheet was filed and charges were framed. Since it was day-to-day basis and the number of witnesses were very limited, although in the charge sheet, if you see, there are 130 odd witnesses and some 200 odd documents and exhibits. But at the time of trial, we cut down the number of witnesses only to the 26 remaining witnesses. We dropped it. So because of that, the trial period got reduced, and we were able to get the result in 1 year, 3 months, or 4 months. Basically, what happened? The first 4 months, the trial was held up because of some high court cases in this regard, where the notification of the SIT itself was challenged on the ground that the notification asked that the report should be submitted to government. On that count, there was a parallel proceeding going in the High Court, and it was under consideration of the High Court. Therefore, the nearly 3 months till we got the judgment from the High Court favoring the constitution of the SIT itself, the real trial could not start. Once that judgment came somewhere in March, and we could start the trial from the May, exactly on the 2nd May, was the first day when the victim was called for the deposition. In between, there were framing of charges and all those things were there.
So there is usually, like I said, there is usually cynicism in such high profile cases that there is political interference, officers are under pressure. But this case is like a antidote to that kind of cynicism. So how was it investigating this case?
To start with the beginning, I say that as most of you know, that it has started with the distribution of pen drives in Hassan district at the eve of election, general parliament election. And after 2 days, the SIT was formed on the recommendation of State Women's Commission. And this case we registered on the 4th. From 4th, we took it, and since there was a team, So we had made it sure that we should be able to complete the investigation within the given time frame. So we were one by one, we completed the investigation. By September, almost in all the cases except one, charge sheet were submitted to the court. And then court, the scrutiny of the charge sheet and forwarding to the trial court, it took another 2 3 months. So by 30th December, the first two cases, including one where we had got the judgment, were transferred to the trial court, that is a session court, for the trial.
So you did not face any kind of political
No.
interference, pressure,
No,
anything?
it was just, I can say you, when we got the case, this formation of the SIT, our mandate was very clear, and particularly my mandate to my team was that you had to look at the victims. Let us investigate. If it is found to be true, we'll charge sheet. If it is not, then we'll B report or C report depending upon the outcome of the investigation. And from the beginning also, there was no political interference or other sort of interference. It was completely free and fair investigation.
Because in this case, the victim in the present case where there has been a conviction of Prajwal Revanna, she was abducted and she was rescued by the SIT. And in that case, you arrested former Minister H.D. Revanna, the SIT arrested from former Prime Minister Devegowda's residence also. So it saw a lot of drama and there were many hurdles to the investigation also, right?
In this case, initial 3 4 days, once we come to know that the victim has been abducted, so those were quite tense, second, third, and fourth, because we never know what will happen to the victim. Forget about any other thing. Our first priority was to somehow secure the victim, because if something happens to her, that too after the formation of the SIT and after it has come to our notice, then it will bring a very bad name to the team itself, particularly the investigation. So we were 3 4 days initial till we could secure the victim. We all of were very tense, to be very frank with that. And once we got the victim, we got a sense of relief. Now that one part is now over. Remaining is starting the criminal procedure, registration of the FIR and all those things are part of our basic job, and we started doing like that. Nowhere in this, during investigation, anybody tried to influence it. Somebody used to give, some person used to give inputs, but effectively saying that influencing the investigation, it was not.
Sir, after this scandal broke out, just to give an idea of how big the scandal was, there were nearly 2,900 explicit clips and featuring over 90 women. That is what we have heard. So only 4 women came forward and registered complaints with the
Yeah,
SIT,
yes,
right?
yes.
So moving on, Prajwal actually fled the country and had gone off to, said to have gone off to Germany, and he came back after over a month. So he was arrested by an all-women team at Kempegowda International Airport at the midnight of May 30th, 2024, which actually went down very well with the public that Prajwal Revanna, who had allegedly abused so many women, was actually arrested by an all-women team. Even the SIT also, apart from you, most of the officers were women. So was that a conscious choice to send an all-women team to arrest Prajwal Revanna?
Yes, it was a conscious choice, and I tell you how it happened. So we were tracking him down as usual. So we knew that has boarded such and such flight, and it's going to land up DIL at this time. So my team members, particularly women team members, they themselves came, sir. We would like to go and arrest. I said, okay, go. It is your case, and if you all want to go and do the secure the accused from the airport, I am very happy. Please go ahead. And that's how this decision was taken. It was not that at my level or no. It is the team members themselves. They asked. I said, okay, please go ahead. You should do it. And it was basically meant for boosting their confidence also. That is one. Now, coming to your second part of the question, most of the team members are women. It was again a conscious decision. In such type of cases, point was how to go to the heart and mind of the victim. And it is very difficult for a male member uh, to enter into their heart and mind. That barrier of speaking will be always there. That
Correct.
inhibitants are on the part of victim as well as the inhibitants on the part of the IU also will be there while talking to them with such type of situation. So it was decided, no, let us have all the IUs, but female, particularly in rape cases. Regarding abduction and other cases, there can be male person, but whenever there is a rape case investigation, let the IO be the female. And that's how it was, the team was selected and team was found.
Okay. Sir, in the Sessions Court judgment that eventually convicted Prajwal Revanna, so we see that they have relied on three major things. One is the victim statement,
Yeah.
which is her testimony, which is the crux
The key,
of the whole
the key,
case.
The key.
The key crux of the whole case. Then two pieces of forensic evidence. One is forensic report of the video where the victim is seen being abused
Yeah.
by the accused,
Yeah.
though his face is not visible. And one is the DNA report,
Yes.
which was, I'll come to the DNA part next. But the forensic report, the judgment itself appreciates SIT for using this technique for the first time in the state. Can you explain more of actually what it is and how it was done?
See, let us look at what did we have
Hmm.
at the start of investigation, which was different from normally available evidence in the case of rape. In the case of rape, normally you get lot of medical evidences.
Correct.
Since here the incident itself has taken 4 years back, nearly 2021 summer, so virtually there were no medical evidence, neither on the part of the body of the victim nor on the part of body of the accused. We were only having video depicting the act. But that video also we were constrained in the sense that it was only having the, it was not having the facial part of the accused. Only other body part were there. Victim was obviously visible. So now to how to corroborate what the victim is saying with what is appearing in the video. How you point out that the person who is appearing in the video perpetrating the act is the same what victim is pointing at. To do that, we embark on the, let us see how many distinctive marks are visible on the body parts of the accused in the video. So that was the basic idea behind it. Then the question came, okay, we had got right to subject the accused for medical examination. And in case of refusal, we can even use force also for that as per the law itself. But whether we can take the photograph is the question, or videograph the body parts. Can it be a part of the medical procedure? Doctor said we cannot do it because it doesn't, our medical ethics don't allow it.
Hmm.
The team of doctors who were examining him. Then we had to go to the court and satisfy the court why we need it. We presented two studies also to the court. Court did go through it, and after satisfying itself, they passed the judicial order. No, the person can be videographed, photographed, but confidentiality of the video and photographs which are being collected at the time of medical examination should be strictly maintained, and the onus of maintaining that confidentiality lies with the investigating of his team. So we had to take the photograph. We could take the photograph and video also. And then we were given to our forensic science laboratory, where they compared the visual distinct identifying marks in the body on the body parts appearing in the video with the photographs and video taken at the time of examination. So we could find depending on the case to case basis, uh, like in this case there were 7 to 8 body marks. In some other case there are 5, 6. Uh, some deformities also. So, coupled with that points, body marks and deformity, we reached a probability that it is mathematically impossible for to have any other person have the same body mass, same deformity at the same point of the body. So that's why we could fix that this person who is appearing in the video is same, which has been subjected to medical examination and whose photographs are being compared.
So essentially, you superimpose the photos and videos taken during the medical examination on the
No,
video that was
I will not say the superimposition.
compare.
Frame to frame comparison. Frame to frame comparison.
You even did the same thing with the scene of crime, sir, the two rooms.
Yeah, that was also the video was very crucial in this.
Correct.
Once the forensic science laboratory said that these videos are neither manipulated nor morphed, then that came whatever is appearing into it is true.
Oh.
So what was the appearance? The act, victim, accused, and the surrounding.
Oh.
Now the victim says that one is where it happened, that is the surrounding, who did it, that is the accused, then whether it was a consensual or non-consensual, which any person looking at the video and the victim's statement, that is where the victim's statement becomes more crucial, can make it out whether it was. Now, I just discussed how we could point out the person. Similarly, the next question was the place where it had happened. Since surroundings of the place were visible, very clearly visible in the video, so we compared the same way. We took the photograph of the surround room and video in front of Panchaj and all the following due process, and did the similar exercise there on the surroundings also. There also the forensic science comes to the conclusion that it is the same place or similarly dressed place. Same place or similarly dressed place. Now the question of similarly dressed place was ruled out because who has to do it?
Correct.
And it was matching with the place which victim herself has identified. So we could pinpoint the place, scene of offense also.
Just to add some context, the victim was actually raped twice, once at a farmhouse in Hassan and another time at a house in Baswangudi in Bengaluru.
Yes.
And both were filmed by the accused.
No. Yeah, both the acts were filmed by the accused.
But both acts were filmed by
the accused. But
Yes.
In case of Hassan, that farmhouse, what had happened, the house where the incident has taken place was demolished in 2022.
Hmm.
The old house which was there where the act was perpetrated was demolished in 2022. So we could not get the
Scene of crime.
Scene of crime for the purpose of comparison.
Okay. Sir, going back to another case which you led the investigation into, the Gauri Lankesh case, in that also you had used a similar technique of gait analysis which was used for the first time in the country itself then in the charge sheet
Yes.
to identify the assailant who actually shot at Gauri Lankesh after you arrested.
Yes.
Can you explain us how that works? It almost works on the same principle.
Similar principle. What happens? It is everybody, every person, the style of walk is different. there will be variations. No two persons they walk similarly or in the same way. In Gauri case, what had happened? It was the house was having a CCTV camera, and the act was captured in CCTV camera. But since it was a rainy day, as well as a little dark also, and from the camera the person was at a distance, so his face could not be
It won a helmet.
captured, and at the same time he was wearing the helmet. Now, how to identify who is this person? So again, we went to in the search of some literature, and we came across this gait analysis. So the person was the accused was, and for we had preserved the scene of crime. Okay, nothing will be touched, and more important, the angle of the camera was not touched at. It was on the same way, same place, same angle. Nothing was disturbed. So we recreated the scene of crime with the accused, and again the video was sent to the
The same
forensic
CCTV
site
footage was only sent.
with the old CCTV footage,
Correct.
and the new CCTV recreated scene of CCTV footage was sent to the Forensic Science Laboratory, Gujarat, who were having expertise. So they did that gait analysis of every step the way he was walking, and the report came positive. Yes, this is the person who is appearing in the original video and matching with the recreated video by the investigating team. And now that technique is being used with so many investigating agencies because we had got number of plenty of cameras. So every crime which is happening outside on the road is getting captured.
Correct.
So it has become a good tool where the person's face is not visible to fix the identity.
Sir, if we see three cases, three major SITs that you have led into the murder of Gauri Lankesh and into Prajwal Revanna's crimes, and also against alleged sexual assault done by BJP MLA Munirathna that you only led. In all the three cases, you have collected DNA evidence. In after many years, also you were able to collect DNA evidence that linked the victim to the accused, or to the case, or to the scene of crime. So, how come you could recover DNA evidence after so long, and why were you actually looking at DNA evidence in after so long? Can you explain in each?
So I tell you what happens when you are investigating, you have to keep on making the effort. Nothing you can say, I will not find anything, or nothing will be there. That should not be the attitude. Okay, there may not be anything, but if so that chance you cannot take. Number one. Number two, your search has to be very thorough. When you are going to search and seizure, then it has to be thorough. Collect everything. So that is the basic principle which I operate. And since to collect everything, we get sometimes, we don't get sometimes. Like in this case also, we searched so many places, the houses put together in different cases. House of accused house in Hodenarsipura was searched, Baswangudi was searched, quarters at Hasanpur was searched, and that was servant quarters in Ganikada farmhouse was searched. On the scene of crime, we could not get anything, although we were expecting. We could find other DNAs, but not the where we wanted to find the victim's DNA, we could not find the victim DNA. Where we wanted to find the accused DNA, we could not find the accused DNA. But coming to this case, it was very, what you say, lady luck smiled on us. The victim was thrown out of the work somewhere at the same time when the incident has taken place. And she was not, since she was a farm laborer working there at the farm, she was not allowed even to collect her clothings, just thrown out. So her clothings remained at that farmhouse, and she had almost forgotten. When we were questioning her and then, okay, where are those cloths? Then she told us that she had left 4 years back there itself. I said, okay, let us see. We were also very doubtful whether there will be anything or not. But in any case, we sent the team. The next worker who had come and was staying in those quarters, what they did just put all those cloths in a bundle and kept in a corner. Now, bundle, since it was kept in a bundle, and this cloth was in middle of it, everything, the DNA got, that semen samples got dried on it, and it did not deteriorate at all. As for deteriorating, it has to be humid and moist climate. If it is dry climate, nothing will happen. Even after 50 years, nothing will happen. It will remain like that. So we could recover the cloth, and our entire clothings, whatever we could recover, were subjected to the DNA sampling, and we could find
DNA of both the
DNA of
accused
the
and the victim.
accused and the victim. Victim, obviously it will be there because the cloth belongs to her.
Yes, yes.
Uh, Finding the accused DNA was
Correct.
a miracle, I can say.
Yes. Even in Gauri case, you actually recovered a hair,
Toothbrush and all those things.
toothbrush and hair from.
Yeah. So, i- these are very small. People use comb. Sometimes one or two hair stain remains in that. They threw it out. Brush. They had used and had thrown it. There also they had tied into a plastic bag and thrown it. So it remained as it is, and we.
So that actually links the main accused in the Gauri case to actually a house they had rented out
Yes.
to carry out the murder.
When we charge it. This is the way from beginning to end an offense has taken place.
Correct.
So they are different steps.
Hmm.
So each step has to be linked. If
Hmm.
I say that an accused had come and stayed in this X place,
Hmm.
then what evidence we are having to show that the accused is staying at that place at the time of commission of crime or for the purpose of conspiracy? So we had to have some evidence. So these are the links which proves part of the act.
I remember in Gauri case, in Belagam, in one forest area where the accused had practiced to use the firearm, you had recovered a empty cartridge of the murder weapon, which was later destroyed. You could not recover that. You could not seize that. You could not seize that murder weapon in the case. But eventually, you recovered a empty cartridge from a forest, which was lodged in a tree. So that linked the murder weapon to the accused.
Yeah.
So how come investigations that you lead, you will get material forensic evidence in most unlikely places?
My always idea remains less reliance on the human witness. The chances of them getting hostile, chances of them getting forget something by the time of giving evidence. So try to do minimize as less as possible on the human witness and more towards the scientific witness. Now, in that case, the incident which you are talking about, yes, they say that this X person was trained in that particular area of the forest. Now, it was a target practice, not a training as such, it was basically a target practice. Now, if somebody has to do the target practice, there has to be some target. There, this was the tree which was shown as a target, and the accused was to shoot at it with a particular distance. So, when it is a target tree, then some bullet has to hit. That's a normal. Other bullets which had not hit may be found there. There was now how to recover it because we don't know it. The training had taken place nearly 2 years back. New set of bark had come it up, so you cannot make it out where the bullet had. And to be frank, I was not knowing there is any such instrument in forensic science lab which can do it. When we tried to find out from FSL, they said no, sir, we have got the equipment. If there is anything large in the tree, we will be able to know, and once we know that, we will be able to recover it. So we used that instrument. I don't remember the name exactly of that instrument. But a scientific team they came, they used it, and well, we got it.
That is why, like you said, in most of the cases that you have done, there are very good material and forensic evidence that actually links. So, asking about the continue the or talk about Gauri case. Since the trial has been made in camera, we also don't have much in updates about the trial. So, where is the trial? Why is it so delayed? And all the accused are out on bail. There was a proposal to form special courts for speedy trial of both Gauri Lankesh and Kalburgi cases. That did not happen. So, where is the trial? How confident of you? How confident are you of a conviction? When can we expect the judgment?
See, one thing is because immediately after charge sheeting, 2 years went in the Corona 20 and 21st. Trial has started, and now we are getting 5 days in a month, continuously 5 days in a month for the Gaudi trial. I can say that more than 70% of the trial is over, and by next year, by February March, we will be able to finish our witness examination and trial, except IOs will be there. That may take another month, depending upon how, because it was a long investigation. We feel that there will be a lot of time required for the examination of the IO, and at the same time, then the similarly cross examination. So, by next year, July, August, or same time, we are expecting that we will be able to get the judgment in the Gauri case. And as far as Professor Kalburgi case also, we are expecting by February, March next year, we may be able to secure the judgment. I am hopeful the trial is going well, hopeful for the positive result. That much I can say.
Sir, in CID as ADGP, you also supervised the investigation into the POCSO case against former Chief Minister B.S. Yediyurappa.
Yeah.
In that also, you have filed a charge sheet.
Yes.
So the trial is yet to begin in that case.
Yes.
Why, sir? Why the delay?
There is a High Court order, stay on the cognizance order taken by the special POSCO court, which we are challenging in this probably next week or something.
In the division
And,
bench.
yeah, in the same bench, there is interim order of stay. So once the High Court passes order of that, depending upon this way or that way, the case will move forward.
If the trial begins in that case, that will also be on a daily basis.
No, it is not mandatory, but the mandate is that it should be within 1 year.
Within
The
1 year.
trial should be over
Yes.
within 1 year.
Okay.
So we expect that it may not take 1 year, it may take 1.5 years, but we are hopeful.
Okay. Sir, coming back to Prajwal case. So you recently held a press conference where you said if more women come forward, like I earlier said, out of nearly 100 women, only 4 women came forward and lodged complaints. You said if more women come forward, you are ready to register cases even now and investigate them.
Yeah.
So taking courage from this judgment, which was sort of unexpected to many people, because there was a lot of cynicism that nothing will happen to him. That kind of cynicism was there. So, do you think taking courage from this judgment, more women will come forward, sir?
Hope so, but even now nearly 1 week is over, 4-5 days, but nobody had come forward even after the judgment. But if they come, again repeat, if they come forward, we'll register the case and do the investigation. There is no limit that they cannot come.
Sir, out of the 4 cases against Prajwal Revanna, one has completed trial and he has been convicted. So, what about the other 3 cases and also about the abduction case where Mr. Revanna was also arrested?
The second trial has started. Already victims examination is over.
Hmm.
So, and third case charge, this cognizance stage it has come up, which is fixed next week, next to next week. So these rape cases, and as far as abduction case is concerned, hearing before charge is going on. So probably another 3-4 months the trial will start.
What about the cases against Munirathna? Where are these?
It may take time. It is, we had charge sheeted, but it has to come into the regular roster.
Hmm.
So it may take some time just for evidence to charge to trial to commence. It may take some time.
Okay. Yes, sir. Thank you, sir.
Thank you.
It was a
Thank
lovely
you.
chat with you.